this, let me say a big thank you to Liz and Hyatt for their diligent work on pulling this training together. A huge thank you to Reggie and Matt, our stellar legal team, for all of their work and guidance in putting the content together. And thank you to Christina and Ruth for helping with all aspects of this training. And to all of you and to your volunteers, a huge thank you for your service to the Guardian Ad Litem program, but also thank you for your comments and suggestions about the court report templates after they were rolled out last year. Since the implementation of the court report templates, we did receive a number of comments, suggestions, and recommendations. And this training incorporates not only those items as well as legal changes. We are recording this training session, and it is going to be so it should be easy to use for staff that aren't able to participate today, as well as for sessions with your volunteers and with any of the attorneys that aren't able to attend. So without any further ado, I will turn this over to Matt Wunsch, and he will get us started. Thank you.
Thanks, Lori. I'm going to go ahead. Can everybody hear me? Okay, I see some heads nodding. Thank you. I'm going to share. So give me just a second to share my screen. Okay, and everybody can see that? Okay, thank you. So thanks again for that introduction, Lori, and I wanted to join in what you said and welcome everybody who's attending training today. We really appreciate you all taking time out of your days to spend some time with us and talk about the court reports and some of the updates that we've made. It's a humbling but really enjoyable experience for me every time I get to talk to especially a statewide group of our staff, because I just I'm always amazed by your commitment and humbled by the level of expertise that's present in these meetings. And so anyway, I'm just very grateful for this opportunity to talk to you all today and to be part of this team working together to implement our court reports. We heard the call that there was a need to do this training, and so Liz Kakris-Jones and Reggie O'Rourke and I have been working on this intensely for the last couple of months, but really for the last year, as the feedback, as Lori mentioned, has been coming in about the court reports. And so we've heard your calls for this training. We appreciate all that input, and really hope that you're going to find this training a useful, hopefully this experience today will be useful for you, but also that this program will be a useful tool if you work with your staff, with your volunteers, and that going forward, it's going to be something that will help our practice in general. So I'll get into the content. We're going to try to keep things right on schedule. And as typical of my sense of humor, I start with a visual pun. One of the things we're going to do, hopefully throughout, we have a large group, it's a virtual training, but we want to do some interactive activities, including some polls. So hopefully Liz can pull up the poll for WebEx here to get us started. But one of the things we want to know right off the bat is what topic are you all most interested in hearing about today? It's changes in the law, updates that we've made to the templates, the tribal, cultural, religious, and other diversity needs or considerations section of the reports, or permanency planning. Oh, I'm sorry, and Liz, hopefully y'all are seeing in the chat, she's asking, please put your responses in the chat.
Thank you.
So I'm seeing a lot of different responses flash up. A, B, C, D, A and B, D. So what's exciting about that is responses still coming in. A and B, A. We're going to talk about all of them. Everybody wins. There's no right or wrong answer here. We're going to talk about the importance of our court reports, their legal significance. We're going to talk about the 21-22 updates, the ones that we've just made, which, as Lori mentioned, are both in response to changes in the law and in suggestions that you all have made to us for how they can be improved. We're going to talk about court report writing and specifically how to interact with the diversity, equity, and inclusion section of the report. We've got some time designated for some FAQs, so a lot of things that have come up consistently from different folks. We're going to spend some time on that, and then hopefully we'll kind of wrap things up with a framework for how to move forward with this training, what you can do, how you can take it to your staff and your volunteers and use it as a template. One other thing I wanted to mention before I move on from the sort of the agenda is there's a 3-hour training. We do plan to have a break at about 10:30. It's going to depend, the timing is going to depend a little bit on how good we are in keeping the train on time, but we do have a break set for about halfway through, so you can plan on that. So we wanted to set out sort of some ground rules for the program today. And really, we promise you we're going to start and end on time. That's our first one, which we've already done the first one. We're going to do the second one too, we promise. One thing we want from you all, and I think the reason it's bolded is we feel like it's the most important thing, is to be fully present. We're going to make this as interactive as we can make it, given the circumstances, but turn off your devices. Please be focused on what we're doing. And sort of in that spirit, keep your cameras on. We realize there are bandwidth and technological limits that may come into play. But if you take a break, if you need to get up and take a break, please turn your camera off. Of course, keep yourself muted when you're not speaking. We're going to have some parts that are more interactive. And so please, when we're at those points in the program, please participate intentionally, really respectfully and focused on the topic at hand. Share the air, let everyone participate and learn from each other. And we're good, like I said, we're going to have some small group time where that can happen, and give grace to yourself and other folks. When somebody says something you may not exactly agree with, that's okay. We're here to learn from each other. And so, you know, both to yourself and to the other folks that you wind up talking to. And this one's important too. If you have questions as we're going along, please put them in the chat. We may not be able to answer them in the moment, but because we're recording and we're going to save the chat, we will be able to get back to you about them. So please, that's the place to do it. And we will get to those questions in time. So I wanted to sort of take a step back on this and start with the big why. And again, sorry, another visual pun, that's a big why. Why did we go into this statewide court report project to begin with? To hopefully to elevate our practice, to support the testimony of our volunteers and staff when staff are in that role, and hopefully to be a tool to help our child clients build resilience through what we are learning and reporting. And we're going to talk through a little bit of those elements now. So how do court reports fit within our team model of representation? I'm sure, as everyone knows, this is our gold standard for how our program works. The GAL program works as a team, and you know, the different team members have different roles. Succeed together. That's how this works. And the out-of-court investigation, as well as our in-court representation, all has to work together. And our different members of our program have different roles in that mission. So our court reports, what role do they play in that? Well, they're a way that we speak to our trial audience. And who is that audience? Well, the most obvious one, of course, is we have a trial judge that we're speaking to, that we're making recommendations to, that we're trying to convince of a particular outcome. But also, eh, our court reports need to speak to our own attorney advocates. They need to help our attorney advocates to prepare for court, to know what the issues are. They're a document that's going to be read by social workers. They're going to be eventually seen by DSS attorneys and parent attorneys. So all of these folks are part of the trial audience that's going to have a chance to read our court reports. And so it's important, I think, that we are thoughtful about how our reports are going to be received by those different members of the trial audience. So what are some things that they have in common? Well, looking at that list, they're all very busy people. When we think about the trial judges in particular, and our own attorneys, we want them to have reliable information that they can count on in making decisions or in deciding what the right legal strategy is for a particular case. They want a document that is in an easy to read format, that the information is presented clearly, so that they can process it quickly and use it effectively. And I think it's important to keep in mind, particularly for judges and attorneys, and I can say this as an appellate practitioner, they're not having direct contact with the child client like our volunteers or staff are. And so that court report is a really important bridge to make that connection between trial judges and attorneys and our child clients. So how does this court report, how does it help us with that? If you remember the first point, our improved advocacy at trial. Well, one of the things we've talked about as we have worked on these uniform court reports is we hope that they're going to be a guide that will help the volunteer through their investigation, to help them to know what are the important things that I need to ask about? What are questions that I should be thinking about? Who do I need to talk to? We hope that the prompts and the instructions are helpful in that way. You know, again, we hope that what our court reports with that guided investigation in mind are going to do is produce better information that help the attorney advocate and the trial court in making decisions in a case. One of the things we've really been aware of, and we'll talk about this in other parts of the training today, is we want to do a really good job of representing all aspects of the child's life. So not just the obvious reasons that they're in court, but a court report that paints a picture of the whole thing. That's what we want to present to the court. We hope that the court reports can be a support for the volunteer's testimony, that show that the volunteer has done the work, you know, that they are not just showing up and testifying off the cuff, that look, here are the steps, all of the boxes that they've checked, all the folks that they've spoken to throughout the case. You know, this is a document that backs all of that up and supports their testimony. We hope that, again, sort of building on some of these other points, that the court reports will help us to have better supported recommendations. We often talk about, we don't want the recommendation section to just be a summary of the court report, that in fact, all of the evidence throughout the court report should lead directly to those recommendations and support them. Again, we hope that the recommendations that we make, and honestly, the whole content of the court report will help our child clients build resilience, that it's a document that they can look back on and see themselves and their circumstances in an accurate way that supports them. And Liz is going to talk about that a little bit in a few minutes. And then the greedy appellate lawyer in me sees this one and thinks it's really important. We want to make sure that our court reports have the evidence in them that supports the findings of fact that we want a trial judge to make. So that even if there's nothing else in the record that supports it, that no other witness testified to it, but it's what we are recommending, that we, through our court report, have provided the documentary evidence that will support the findings of fact that we need. Like I said, the greedy appellate lawyer in me really likes that one. So I wanted to talk a little bit about our team model and how that plays out on appeal. And the visual metaphor that I always use for that is links in a chain, that we have, evidence that hopefully leads to good findings of fact that lead to good conclusions of law, and then conclusions of law that support ultimately what the trial court did. And that's how an appellate court is looking at our cases. They want to see that each of those links in the chain are solid. If any of them are not solid, the chain breaks, and that's when we get cases that are reversed and remanded on appeal. And that's the result that we're all trying to avoid. I think a really important piece of that, specifically as it relates to our court reports and appeals, is that appellate courts work in paper. And I put paper I put it in quotes, it's sort of in air quotes now as I'm talking. Appeals have become a lot more electronic, so the paper is more digital than it used to be. But the appellate courts only see what makes it into the record or the transcript, which are basically the documents that are filed in the trial court. And so I took a picture of my desk on a day and time. And you can see those 3 binders. That's a record on appeal in one case. Most of them I get are electronic now, but I happen to have one at the time that was old-fashioned, printed out and served on me. But that's what an appellate court is reviewing. It's all of that paper that gets accumulated in the file. And I know you all know that file well as it lives in the trial court, but I hope that this picture at least is a concrete demonstration of this is all the appellate court sees of a case. It doesn't know the child. It doesn't know the parents. It probably doesn't know the attorneys. All it really knows is what makes it into that paper that gets in front of it. And so our court reports are an incredibly important part of that. So who are the appellate court, or who is the appellate court audience for our cases? Well, we've switched back now. Most of our appeals, or all of our appeals now, are going to go through the Court of Appeals first, and then a few of them each year will make it to the Supreme Court. So that audience is the justices and judges of those 2 appellate courts, and then the staff that supports them, the staff attorneys and research assistants. And they're experienced attorneys. Some of the research assistants are new attorneys, but they're not necessarily experienced in district court or in child welfare cases. So for a lot of them, especially the research assistants who may just be rotating through for a year or 2, this may be the first time that they've ever seen one of our cases. And to me, one of the big advantages of these statewide court reports is that our court report will look the same, whether you've seen one of these cases or 100 of them, and it'll look the same throughout the life of the case. And so I'll talk about it a little later, but I feel very strongly that that helps us build credibility and reliability to that appellate court audience. Just like the trial courts, the appellate courts are really busy, particularly the Court of Appeals has a huge caseload, and our cases are just one part of that. And like I said before, they're going to be working based on what's written in the record and the transcript. So if it doesn't make it into a document that gets in front of them, they don't know about it. So they use our court reports, and I was trained to use our court reports this way when I worked at the Court of Appeals, to provide background information and context about a case. We all know that not every piece of information makes it into the trial court's orders. A lot of really important stuff winds up in the court reports, maybe doesn't get translated into an order. So they're a great tool for an appellate court to really understand what happened. Sometimes the appellate courts wind up using court reports to support the trial court's decision, and I'll have some examples of that in just a minute. And then also to support their own reasoning of how they're looking at the case. So if you were with us in the fall at the statewide meeting, you remember Chief Justice Newby spoke to us about how the Supreme Court reviews our cases. And I trimmed just a little snippet of that conversation that I wanted to play for you today.
with regard to the other facts in the record, it's just important that the judge and DSS, and to the extent that the guardian ad litems are a part of that, just to ensure that the evidence is properly in the record and that that evidence supports what the trial court finds, because generally then the findings are to support the conclusions of law, which would be ultimately in the dispositional stage, it's best interest of the child. So I simply put that out there as you're interacting with DSS in particular, but interactions in the court. It breaks my heart to see orders sent back to the trial court saying, write a better order. With regard to.
So I think that's a really powerful, at least for me, from an appellate perspective, the Chief Justice saying that they hate to send orders back just because the findings of fact aren't there, that our court reports can be the support for the findings of fact that need to be made is a critical point. That was a huge, I have to tell you, I sat up and paid extra attention when I heard that. So here's In Re Shu, which is a case from the Court of Appeals, well-established law now about how our court reports can support trial court's orders on appeal. And then I've just pulled these are basically just some random case citations with quotes where the appellate courts are saying, yep, we relied on the court reports from guardian ad litem to help support this order. So it's not just a theoretical thing or a talking point. Our court reports, when they are really good and they have the information in them that they need, they can be the difference between an order that gets reversed because the findings and the evidence just aren't there, and an order that gets affirmed. And that, again, the greedy appellate lawyer in me, I want that to be every case. I want our court reports to stand in that gap and to fill in that information that helps get orders affirmed when they need to be affirmed. So to that goal, and this is again sort of a step back, but some background. What we produced is 6 statewide court report templates with instructions for the disposition hearing, the review hearing, the permanency planning hearing, the TPR hearing, the post-TPR hearing, and the youth transition to independence hearings. So those are sort of the 6 fundamental hearings that we have. We know there's some other situations that aren't directly accounted for, and Reggie's going to speak to some of that in the FAQ section. How do we deal with some other things that may come up? But these are the 6 that we have generated for use around the state. And I'm sure y'all are familiar with these already. So each report, for each of those hearings, there's a blank template. That's one document that's a fillable PDF. And then, of course, there's a separate instruction document that has the instructions that we've written in blue ink. We hope what our goal was is to make them self-contained and self-explanatory. Now, I know that sounds great. And, part of why we have training is because maybe there needs to be some additional explanation on some points. But we really hope that they are user-friendly, that people can work through them using those instructions and feel comfortable filling in all the information that needs to be in the court report. They're also branded, which is really important to us, with the GAL logo. Again, that's part of that goal of making them look the same. Whether a case is from Murphy or Manio, that we know this is the same unified guardian ad litem program, and that whether a trial judge is practicing sitting in one district or another, they're going to get the same court report from us with the same information that's going to be just as helpful for them in making their decisions. And if that case gets sent up on appeal, the Court of Appeals is going to look again at the same court report with the same really great information, help it evaluate that order. So the major sections of the court report are the history, our investigation, the current information about the child, the wishes of the child, the issues for the court's attention, and the recommendations section. Of course, the recommendation section, we hope, is sort of the summation of all of that information that we've provided throughout the body of the report. And again, as I mentioned already, what we hope is that all of that information, that accurate picture of what is going on with that child and the child's family at the time of the hearing, is going to be a tool that's going to help that child build resilience in the long run. And so I'm going to hand off at this point to Liz, who is going to talk a little bit about our role in that.
Hi, everybody. It's great to see you. Thank you, Matt. Every time you speak, I learn something new, so I appreciate that. One of my favorite things to talk about is resilience for our children, and I appreciate the opportunity to do that again in this context, because I think that everything we do really kind of leads to that path. If we're doing the best work we can possibly do for children, right? That's our ultimate goal. Permanence helps build resilience. Permanence is our ultimate goal. And so when I think about our court reports, I think about the way that they communicate what we're doing as advocates to build that resilience for the children we serve every step of the way. And the way that that happens within the context of the court report, I think is pretty powerful. And there's one term that's not on this little bulleted list, and I wonder if anybody would love to guess what it is. There's one term, and it's in our mission statement. So we've talked about permanence, we've talked about volunteers, we've talked about advocacy, and of course, that term, I'm going to give a second for somebody to maybe throw it in the chat as I do this. So help focus. Thank you, Jody. That's a great one. Wasn't the one on my mind because that's not necessarily in our mission statement, but I'm going to offer that it's best interest, right? And if we're working in the best interest of a child, we want to be building resilience. And if we know the child, we can do that, because if we know the child, then we really are able to serve their best interest. And when we're doing that, we're helping them get to permanence. And the way that Reggie and Matt and I continuously talked about this through every section, through every review, through all of this, is that our court reports tell a story. And I have often thought about how our whole court documents, all the documents we pull together in that file, are like a biography. They are a series of words. I'm just going to be really kind of concrete here, that we keep putting into this larger file that puts together the picture of a child. And the more robust and the more cohesive and the more involved and contextual we are about that child, the better that story is, right? The more closely we are tied to their best interests, because we know the child, we know their story, we know the story of their family, we know the story of who they are when we meet them, and who they are becoming, and who they may become. And that's part of what we do. And so I want you to think about your court reports in that way. And that's why they are framed in the way Reggie and Matt came up with, which is more of a narrative than a bulleted document. Sometimes bullets are really powerful and we use them, and I don't shun them in any way. I use them all the time. But that is kind of very intentionally why these documents are put together the way they are, because we want to tell that narrative in a way. And as Matt said a little bit ago, part of what our reports do is give context to the judge, so the judge can make these great recommendations that we're asking for. And those recommendations certainly are around, how do we get a child to permanence? What services do they need? What does the family need? How do we keep them connected to their family? How do we keep them connected to people who are available to them to help buoy them in tough times, and help them realize their potential. So I'm going to give you 3 words. I'm sure you've heard them before in talking about resilience. One, for a child to really kind of build their best resilience, there are 3 things that we want to be sure can happen for them. One, or we work towards them. One is they need to believe they're capable. The other is they need to know they're loved. And the third is they need to know they're worthy. And all of those things are true for all of our children. And part of what we can do is help make sure that that message is conveyed to them in every experience they have with us. And it's conveyed to the court that those are the things that we're putting together so that they feel those things. And in that regard, I would just offer that's how we build resilience. And I'll stop there. And I think that we are at the end of this section. Am I right?
That's right, Liz. Yeah, we
Thank
put these slides in just to let everybody know for ourselves because we're recording in sections. And so this is us telling ourselves when to stop and start our recording.
So, hi, you go ahead and stop us, and then we will start again.